So I'll start with employment contracts. And one of the things I hear often from clients when I ask them what the employment contract is when a dispute has arisen is they might tell me, well, we don't have an employment contract. But what you need to be aware of is that in all cases, anytime you have an employee, somebody that's doing work for your business, there is an employment contract. The employment contract may not be in writing, it might be oral, an oral contract, but there is a contract. And you can see right off the bat then that what the advantage of a written contract is. You have certainty of terms, or at least you hope you have certainty of terms if your contract is written properly. Absent a written contract, you have a he said, she said, where both sides are saying, well, you promised me this and you promised to do that, and you're not living up to your promise. So what I'll do is I'll talk about some of the most important elements of an employment contract and the terms and provisions that you want in every employment contract, no matter how obvious or trite it might seem. The first one, and really the most important because it goes to the heart of the employment relationship, is the term. Is it a fixed term employment contract or an indeterminate term employment contract? And this simply means, is it a 1-year contract or a 6-month contract, or is it you work here until you leave or until we let you go? And it might seem kind of obvious that everybody would know the terms and conditions that you've hired people on, but you'd be surprised what you might see in employment contracts sometimes. Certainly you might be surprised at the disputes that I've seen when there is no written employment contract. I mean, I've seen an employer, think that they hired somebody on a 1-year contract, and when the 1 year comes to an end, the employer says, okay, well, thanks for your work, see you later, and the employee says, well, I'm not going anywhere. I have an indefinite term contract or an indeterminate term contract. And you can imagine the shock of the employer in that case, but you've set yourself up for quite a fight. So that's a term that needs to be written right in, and it needs to be expressed. So you don't want to see, I've actually seen an employment contract where there was no term specifically mentioned, but under the compensation or salary part, it said that the employee will be paid whatever, $50,000 or so for 6 months. And the employee took the position that meant they had a salary of $100,000 per year, whereas the employer took the position that it meant after 6 months, I don't pay you anything. So again, these are things that you want to have expressed in an employment contract. Another one is the probationary period. And probationary periods is a period of time in which an employer can test out an employee essentially, and at the end of that period, let them go without having to pay them provide them with any notice or pay in lieu of notice. And there does seem to be a misconception out there that probationary periods are automatic in Ontario, that everybody is on a probationary period for 3 months. And that's not the case. The Employment Standards Act does say that no notice is required, no termination pay is required if the employee has been working for fewer than 3 months. But that doesn't absolve the employer of their responsibility to provide notice under the common law. And JP will talk about the difference between employment standards notice and common law notice, but the point is that unless the contract specifically refers to a probationary period and specifically states that X number of months or weeks or days shall be a probationary period, then there is no probationary period, and the employer must provide reasonable notice on termination. Certainly, every employer should have a termination clause in the contract. And the termination clause, as you know, that termination is the area that gets employers into the most trouble and creates the most litigation. So a termination clause creates certainty for the employer as to what the obligations will be at the end of the employment relationship. In many cases, especially for more junior level or low level employees, you'll want to limit their entitlements to the minimum standards of the Employment Standards Act. In other cases, you may not. If you have a senior level employee, you may want to provide them with 6 months, 8 months, 10 months of notice. But if you don't have it in the employment contract, then it becomes very uncertain and very difficult to figure out exactly what the entitlement would be on termination. And the last clause that I'll talk about at all, or in any depth at all, is the restrictive covenants. And restrictive covenants, these are the non-compete clauses and the non-solicitation clauses that you see in many employment contracts. And the first thing to keep in mind with restrictive covenants is that the courts consider these clauses that restrict the ability of an employee or an individual to carry on their chosen trade, their field of expertise, they consider these clauses prima facie unenforceable. So that's your starting point anytime you try to enforce it. You need to assume that if you try to enforce it and you walk into court, the first thing the judge will say is it's not enforceable unless you tell me, you employer, why it is. And why it's reasonable. And that's the test. It's unenforceable unless the employer can prove the reasonableness of the clause. And reasonableness is one of those words that comes up a lot in the law. And it's kind of a loose concept and can change from case to case. But at the end of the day, what a court's looking at to see whether a restraint of trade provision, non-compete or non-solicit, is reasonable is whether it protects a legitimate proprietary interest as opposed to simply trying to limit the rights of an employee or the ability of an employee for the sake of it. And so the elements that a court will look at are the geographic and temporal limitations. That's a big one. And by that I mean in what area of the world can this employee not compete in? So non-compete might state that you can't compete in the city of Ottawa, or you can't compete within 5 kilometers of the business, or you can't compete anywhere in Canada, or you just can't compete, period. Whether or not one of those geographic limitations is reasonable depends on the circumstances. So if you have a corner store, for example, and you've got a non-compete in there, or a hair salon and there's a non-compete in there, or some other physical, locally based business that serves the surrounding community, if you have a citywide restriction, there's no way that would be considered reasonable. So a few blocks, a few kilometers would probably be, or more likely be found to be reasonable. Whereas if you're in online sales where you're selling services or goods through the internet, perhaps a national scope, provincial scope would be reasonable in the circumstances. Certainly limiting it to the city of Ottawa may not make sense if your targets, if your customers are across the country. And it's the same thing with temporal limitations. For example, an accounting firm might have a restraint of trade provision for their accountants who go and work for a competitor. But a 5-year limitation, for example, would probably be considered unreasonable. I think a 1-year limitation might be reasonable, and that's because it's very cyclical kind of work. Audits are annual, tax submissions are annual, etc. And so your contact with the client might be one real intense contact per year. So those are the kinds of things the court will look at. And the point to be aware of is that what the court wants to see is that it's as narrow as possible to protect your legitimate interests. And that's where these restrictions on geographic and temporal limitations come into play. Something to keep in mind is the difference between a non-solicit and a non-competition. A non-competition is very difficult to enforce. Not impossible, but very difficult, whereas a non-solicitation, where the former employee can't go and directly solicit their former customers, is more likely to be enforced. Again, within reason, and again with reasonable limitations. So if at any point you can get by for your business with a non-solicit and it won't hurt your business too much, you're better off doing that. The other thing to remember is that courts won't read down these provisions. And what I mean by that is that if the geographic limitation is all of Canada, and a court said, well, I think that all of Ottawa would be reasonable, but you've chosen all of Canada, they won't read it down. And if it's found to be unreasonable or unenforceable, then the whole thing is simply thrown out. So if you've got a clause that says you can't solicit and you can't compete for 1 year, and the court says, well, that's not enforceable because you can't compete anywhere in Ottawa and that's too broad, the court will throw out the non-solicit too. The court will just throw out the whole thing and there'll be no restraint of trade provision at all. So if you want these to be enforceable, you need to ensure that you're not overreaching to cover yourself. That won't work. That will end up having the whole thing thrown out. So with that, I'll turn it over to JP. Actually, what I'll do is I'll just mention this last point first, and that's the issue of consideration. Sorry about that, JP. But One thing you ought to be aware of as well is that a contract is enforceable where there's consideration. So a contract has to be something for something. And work is that something. That's what the employee is giving you, the employer, in exchange for money. So if you wait to have the employee sign an employment contract until after the start date, once they're already doing the work, then you're going to have a real problem enforcing that contract. Because they've already given you the consideration, and they know that you've already promised them money. So the contract is formed at that point. So I understand that for a lot of growing businesses, sometimes you just need somebody in the door right away. But that can create problems for you. You need to be somewhat patient if you can, so that you get an employment contract to this employee before they come in the door. Because you're going to be left without the termination clause, without the restraint of trade provision, or without other terms that are important to you. So do keep that in mind. Try to keep a good precedent on hand that you can just scribble in if necessary, if you're really short of time and you can't talk to your lawyer.